The next area is mens rea. Mens rea means very simply a guilty mind. The defendant knew what he was doing was wrong. It's as simple as that. Mens rea is really nothing more than a guilty mind. The defendant knew what he was doing was wrong. There are different ways that we're going to find mens rea. So for example, let's talk about specific intent crimes. The definition of specific intent crimes is the defendant must have the specific intent to commit that crime. Okay, so mentally he has to actually mean for that crime to occur. All right, so there are some examples of specific intent crimes are SAC, which is solicitation, attempt, conspiracy, and all of the theft crimes. Also intent to kill murder, voluntary manslaughter, and heat of passion killings. Okay, so that's basically what voluntary manslaughter is it's heat of passion killings. Let's go over that once again. Specific intent crimes, where the defendant must have the actual mental specific intent to commit those crimes, are the SAC crimes, which are solicitation, attempt, and conspiracy. All of the theft crimes are specific intent crimes, don't forget that. Intent to kill murder, and voluntary manslaughter, which is basically a heat of passion killing. Those are the specific intent crimes. There are other ways that we're going to impose a mens rea on a defendant, and those are through general intent, and that means the intent just to commit the crime. So let's go over a definition for general intent crimes. The definition is: there is no specific intent needed to commit a crime. Intent can be inferred from the defendant's conduct. Intent is satisfied by purposefully, knowingly, willful, wanton, or reckless conduct. Now let's go over some of the general intent crimes. General intent crimes are rape, battery, arson, mayhem, involuntary manslaughter, and depraved heart murder. Once again, the general intent crimes are rape, battery, arson, mayhem, involuntary manslaughter, and depraved heart murder. So under the model penal code, what's going to happen is when you are on an exam, for example, on the MBE, they're going to give you statutes, and they're going to say to you, they're going to give you a statute, and they're going to say answer according to model penal code. And they're going to use words like purposefully, knowingly, recklessly, negligently. You know, this language is really what you're going to see in the model penal code types of statutes. So that's what you want to look for. Remember, they don't have to have the specific intent to commit the crimes. It's almost as if we infer intent on general intent crimes. So let's go over purposefully. I'm going to give you a definition for it. Purposefully is really intentionally. It's the same thing. And the definition is where the defendant acts with a conscious objective to engage in a certain conduct or cause a certain result. Let's go over that again. Purposefully is the same as intentionally, and the definition is where the defendant acts with the conscious objective to engage in certain conduct or cause a certain result. Now let's move on to knowingly. Knowingly is basically awareness of certainty. Again, knowingly equates to awareness of certainty. So let's go over the definition of knowingly. The definition is where the defendant acts with the knowledge or awareness that a result is certain to occur. Next one, let's go over recklessness. And recklessness is really a disregard for a risk. Again, recklessness is a disregard for a risk. A definition: defendant knows, has a subjective awareness, there is a substantial and unjustifiable risk of harm that will result. Once again, recklessness, which is a disregard for risk to others. All right? Definition is the defendant knows or has an awareness that there is a substantial and unjustifiable risk that the result will occur. Now let's talk a little bit about criminal negligence, because we can also find somebody guilty of a crime through criminal negligence. The definition for criminal negligence is a gross deviation from tort standard of care that an ordinary prudent person would commit in a similar circumstances. I'm going to talk about some of those later on as we go through the actual crimes themselves. We'll talk about when we can use, when the specific intent needs to occur and when general intent needs to occur as we actually go over all of those particular crimes themselves. Then we have what's called strict liability crimes. Strict liability crimes, the defendant's state of mind has no effect. Absolutely no effect whatsoever on whether we're going to find him guilty of the crime or not. Again, strict liability crimes, those are crimes where the defendant's state of mind has absolutely no effect on the result of whether he's going to be guilty of the crime or not. Just the fact that he committed the crime is enough. The definition of strict liability crime is crimes where the defendant's mental state is immaterial. The defendant's conviction will rest solely on the fact that he or she committed the prohibited act. So let me give you some examples of a strict liability crime. Generally health and safety issues. So something like parking in front of a fire hydrant, that's a strict liability crime. Speeding would be a strict liability crime. Another strict liability crime would be statutory rape. The next thing that we need, number 3, the next element that the prosecution must prove is a concurrence of both actus reus and mens rea. So the definition of the concurrence of both actus reus and mens rea is very, very, very simple. The defendant must both have a guilty act and a guilty mind at the time he committed the crime. Again, concurrence is nothing more than, definition, the defendant must have both a guilty act and a guilty mind at the same time the crime is committed. That's all concurrence is. Causation. There's factual cause, but for, and substantial factor test. You really only need to go into causation when you have a third party who's involved, or maybe even an act of God. So causation is basically when we're going to say, is the defendant the legal or proximate cause of the resulting crime or injury? So causation between conduct and resulting harm must not be too remote. Only argue if you see an intervening force or a third party, all right? The last one is the resulting crime or injury. Someone's going to rob somebody, you're going to see a robbery. Someone's going to rob a bank, you're going to see them rob a bank. If they're going to commit conspiracy, you're going to see them making an agreement, all right? So basically that's what the resulting injury or crime is. Once again, let's go over those 5 classifications of crimes, and then we'll move on to the next section. The 5 classifications that the prosecution must prove in order to find a defendant guilty of a crime is, number 1, actus reus. Number 2, mens rea. Number 3, concurrence of actus reus and mens rea. Number 4, causation. Number 5, resulting harm or injury. Okay? That's all that the prosecution needs to prove.